Tribunal, probably being, Mr. Gambini's being a little too truthful there. But let's go over this. So a lawyer is forbidden from making a false statement of fact or a false statement of law to the court. In other words, do not lie to the court. More than anything else, in terms of getting in trouble at the bar, lying to the court, lying to the bar will always get you in trouble, more so if you get caught. 2, you cannot fail to disclose a fact to a court when disclosure is necessary to avoid assisting a criminal or fraudulent act by the client, subject to Rule 1.6. So in other words, if your client has lied to the court, Rule 3.3a2 would require you to disclose the fraud on the court in a civil case. Some of the comments we'll get to in a minute deal with the back and forth and the ethical conundrum you run into when your criminal client has perpetuated a fraud on the court and they perjured themselves. But in a civil case, at least, the comments make it pretty clear. If your client lies to the court, you need to correct that so you don't perpetrate a fraud on the court. Part 3, you can't fail to disclose to the court controlling legal authority and the subject jurisdiction that you know about that is adverse to the position of your client that the opposing counsel doesn't get to. And number 4, you cannot offer evidence that you know to be false. This somewhat piggybacks on the Rule 2, but it is entirely different. Let's say you have a third party, you know that they're lying, you can't put them on the stand. Even if your client wants you to, you can't do it because you know they're going to lie. If you know a document has been forged, you can't put that up as true. And second sentence, obviously if you offer something that you believe is true at the time, you come to know later that it's false, you have to take reasonable remedial measures, meaning you have to amend a pleading, you have to withdraw the evidence, you have to let the court know that it's false. Fairly straightforward. Don't lie to the court. If you come to know something is untrue, you have to tell the court. So B, a lawyer can refuse to offer evidence you reasonably believe is false. So under the ethics, your client comes to you with a witness, hey, put this person on the stand, and you reasonably believe they're lying. You don't just think, oh, they just don't mesh with me, but they're telling you stuff, and physical evidence that you know about contradicts what they're telling you. You have a strong and reasonable belief that they're lying. You can ethically refuse to put them on. So C, in an ex parte proceeding, a lawyer shall inform the tribunal of all material facts that the lawyer knows about that enable the tribunal to make an informed decision whether or not they're adverse. So if you're going in for an ex parte protective order, let's say, and you know of facts that might hurt your client, since it's ex parte, 3.3c would still require you to disclose those facts to the court. In D, a lawyer who receives information establishing that a person other than a client has perpetrated a fraud on the tribunal shall promptly reveal the fraud. So this ties into A4. If you get ironclad information that shows that a witness is lying, the other side is lying, they're not your client, you have to tell the court. There's no, you're going to sit on it, use it and cross. There's no, you're going to let it go this time. You're ethically obligated to report that. Okay. Comment 1, we're not going to go over comment 2 for obvious reasons, but comment 1, your job is to argue your client's case. You need to present it with persuasive force. And you have to do that while maintaining confidences of the client. However, you don't vouch for the evidence submitted in a case. The court's job is responsible for assessing its value. So what does this mean? You have to present your case within the bounds of the law. You don't have to make necessary value judgments on the evidence beyond whether or not you reasonably have a good faith basis of believing it's true or false. It's not your job to assess the value. The court will do that for you. That's why we have them. But you do have to do that. So this is long. I'm going to try and break it down in discrete chunks. So as an attorney, you are responsible for pleadings that you file. You don't have to know of every fact in them yourself. You don't have to be an eyewitness. That would cause all sorts of problems if you did. but you are responsible for the facts that are in them. You can rely on your client. You can rely on what you believe are honest representations of a witness. They're not necessarily your assertions, but you're responsible for them. It then says, section 8.01-271.1, and it goes through what that imputes to a certification when you sign a pleading. So when you sign a pleading, what you're certifying is that you believe, after reasonable inquiry, so this charges you with inquiring, with doing a background investigation and making sure whatever you put in that pleading, you have a fact to back it up, or you have the law to back it up. But when you sign on the line, you're saying you believe after reasonable inquiry there's a factual basis for this pleading. You're also signing on the line saying you believe that the existing law or a good faith argument for the modification, extension, or even reversal thereof supports your pleading. Once you sign on the line, you're implicitly making those three statements to the court. Now, if you're filing an affidavit or something that purports to be of your own knowledge, you'd better know what's in there, and you had better have made a reasonably diligent inquiry. Now, the next part has to do with, well, what if I don't tell the court anything? And it says there are instances where if you don't act, if you don't get up and tell the court something is false, that is, in effect, the same thing as lying to the court. So the obligation, Rule 1.2c tells you that you cannot advise a client to commit or assist them in committing a fraud. And 8.4b tells you that's patently unethical. You can't do that. But you will still have to take reasonable remedial measures if you come across a situation where there's been a misrepresentation. So silence, you're not allowed to rely on silence when you know something to be false. And that is the crux of this comment. So number 4, in a nutshell, says, if you make a legal argument that is based on an incorrect reading of the law, you have lied to the court. That is this large comment boiled down into a nutshell. It goes on to say, law is complex, it's ever-changing, so the court may not know all of the law at the time it decides the case. This is why we have this ethical obligation. You can't lie about the law to the court because it's so complex. They are, in part, relying on the litigants to provide it to them, to educate them on the topic. Therefore, if you're making an assertion of law and you know it's false, that is the same as lying about a fact. That doesn't mean that you cannot come up with a creative and logical interpretation saying that the law should be extended to this fact pattern, it should be reversed. That doesn't mean that at all. But if you know what you're saying is wrong, you can't do it. So 5, we discussed this a little bit earlier, but basically, if your client brings you a witness, you know the witness is lying, you have to refuse to offer the witness. It's that straightforward. Number 6, and this duty here is going to conflict with your duty in Rule 1.6. That's just going to happen. So 6 deals with when false evidence is offered by the client. What do you have to do? Because you're not allowed to breach client confidentiality, but your client's just lied to the court. So 6 says, upon ascertaining material evidence is false, first thing you got to do is try and talk your client out of it. If you catch it before trial, you have to tell the client, look, you can't lie to the court. If the court catches you lying, it's going to destroy your case anyways. Don't do it. You really need to do it. Stop. If that's ineffective, you're going to have to take reasonable remedial measures. So this says, except in the defense of the criminal accused. In other words, for civil cases, if your client lies to the court, you have to correct it. You have to tell the court, Your Honor, flag on the play. May I approach the bench? My client just told a whopper. You have to do that if you know that fraud has been perpetrated. There are no exceptions to the rule, no countervailing duties. This is one of the situations in D where your silence would be tantamount to fraud. You have to correct it. It really stinks. So that is the essence of comment 11. 12 deals with criminal cases, because criminal cases, they have a little bit more at stake than civil cases. If you're representing a criminal defendant, if you lose the case, they're probably going to go to jail. So, and there are enhanced constitutional protections for criminal defendants, and the ethical rules get that. So 12 is whether an advocate for a criminal accused has the same duty of disclosure has been intensely debated, because there is a higher risk. There are enhanced constitutional protections for criminal defendants, as there should be. Everyone agrees that the lawyer should try and talk their client out of offering perjured testimony. I don't think we have anyone in the room that would disagree about it. There are plenty of sound case reasons to do it outside of your ethical duty. It's just something that you need to do. This rule says if the confrontation with the client occurs before the trial, the lawyer ordinarily can withdraw. This is one of these motions, defense attorneys, you move to withdraw, the court asks you why, say, Your Honor, an ethical conflict of interest has arisen. I can't tell you why. I used to get those all the time as a prosecutor. It happens. It is what it is. Sometimes, and this is also usually a good opportunity to call the ethics hotline. I'll make a shameless plug for them, and paper your file and do what they tell you to do. Withdrawal before trial may not be possible, however, because trial is imminent, because the confrontation with the client doesn't take place until the trial itself, or because no other counsel is available. So those motions, even if the other side says, okay, we don't object, the court still calls the ball and can force you to stay in the case. That puts you in a pickle. Most of you are going to ask, well, what do I do then? These comments try and tell you what to do. The most difficult situation arises where the accused insists on perjuring themselves, and your effort to rectify the situation can increase the likelihood of them being convicted. Obviously, if you tell the court, Judge, I have to withdraw because my client is going to perjure themselves, that's not going to look good on your client. If you're in a bench trial, the judge is probably going to think, okay, this guy's guilty as sin. So obviously not something that you want to have happen. Also opens the door for a possibility of a perjury prosecution. Perjury in and of itself, those of you that didn't know, is a class 4 felony. That's 2 to 10 years in prison if you were convicted of that. On the other hand, if you don't exercise control over the proof, if you remain silent after you've put forth this perjured testimony, you're perpetrating fraud on the court. So on one hand, you don't want to tell the court, hey, my client's about to tell you a whopper, and have the court convict the client appropriately, but you also don't want to perpetrate a fraud on the court. So we have 3 resolutions to the dilemma. One is to permit the accused to testify by a narrative without guidance through the lawyer's questioning. This compromises both principles. It exempts the lawyer from the duty to disclose false evidence, but subjects the client to an implicit disclosure of information imparted to counsel. Another suggested resolution of relatively recent origin is that the advocate be entirely excused from the duty to reveal perjury. The perjury is that of the client. It's a coherent solution, but it makes the advocate a knowing instrument of perjury. So behind door number 3, that it appears our bar has endorsed, the ultimate resolution of the dilemma, however, is that the lawyer must reveal the client's perjury if necessary to rectify the situation. A criminal accused has the right to the assistance of a good lawyer, a right to testify, and a right of confidence with that lawyer. However, an accused should not have the right to a lawyer that's going to assist them in perpetrating a fraud on the court. It also says the advocate has an obligation, not only in professional ethics, but under the law, to avoid implication in the commission of perjury or other falsification of evidence. So in other words, it appears that Virginia has adopted the rule, if your client tells a big whopper in open court in a criminal case, you have to rectify that. If you can't get out of the case beforehand, you're going to have to rectify that. And I would also say, under your duty to inform your client, you're going to have to tell your client that you're going to have to tell the court that they're lying. That should work. Doesn't always. but you have to do that. And frankly, if we had any prosecutors left in the room, I would say you can make a good faith argument for the extension of the perjury statute, given that we as lawyers have an ethical duty to argue that you are actually aiding and abetting in the commission of perjury if you don't tell the court, which in and of itself is a felony. So you likely, and you definitely need to tell the court. So this is big for a Friday afternoon, but we're going to keep going. So ordinarily, you have a limited responsibility of presenting your client's side of the case. However, in ex parte proceeding, that's different. They actually give the application for a temporary restraining order. Essentially, our system of justice is adversarial. So you're making all of the good points for your client, and the court is relying on the other party, the other side, the other attorney, to make all of the good points for the other side. The theory being that if you ratchet up all of the points for each side, you're going to find the truth as a third-party observer. However, the object of an ex parte proceeding is to yield justice. And if you don't have the other side there by definition, your ethical obligations kick in and they temper your advocacy somewhat. So the judge has a responsibility to give the absent party justice. And the lawyer for the represented party has the correlative duty to make disclosures of material facts that the lawyer knows. This only covers what you know. And that you believe are necessary to an informed decision. So if it's just a fact out in the blue that has no bearing on the matter, that's different. If it's a fact that's material to a protective order, it's adverse, it's material to your client, you need to disclose that. Now, for purposes of the rule, ex parte positions do not include grand jury proceedings. So prosecutors are off the hook here. And do not include proceedings which are non-adversarial, including administrative proceedings in which a party chooses not to appear. However, a court, including an admin court, might have a rule other than controlling precedent that requires disclosure even if our rules don't. So you do have to comply with those disclosure requirements. It does say the failure to disclose information as part of a legal challenge to a demand for disclosure will not constitute a violation of this rule. Okay.
Mr. Reed, it is out of sheer.
Quick question. Has anyone in here seen the movie Liar Liar? Jim Carrey. He falls under a spell. He is not able to tell a lie in court. So I thought this would be apt in terms of dealing with how to honestly present a case even if your client is less than stellar.
With morbid curiosity, I'm allowing this freak show to continue. Mrs. Cole, you dare.
Mrs. Cole, is this a copy?
Yes.
It says here you're a blonde, are you? If you don't remember, perhaps Mr. Falk will.
Brunette.
We can play the tape again. Maybe it's on there.
I'm a brunette.
Thank you. Now let's see. Weight 105? Yeah, in your bra.
Your Honor, I object.
You would.
Bastard!
Hey, quiet! Overruled. Wait.
118. All right, fine. I'm 127.
Uh-huh. And it says here you were born in 1964, but that's not true either, is it? Is it?
No.
Can you tell me what it says here on your birth certificate under date of birth?
Your Honor, I object. What does this have to do with anything?
Overruled. Mrs. Cole, answer the question.
1965.
Now, let me get this straight. That would mean that you lied about your age to make yourself older. But why would any woman want to do that?
I changed it so I could get married.
And the truth shall set you free. My client lied about her age. She was only 17 when she got married, which makes her a minor. And in the great state of California, no minor can enter into any legal contract without parental consent, including
Prenuptial agreement.
prenuptial agreements. This contract is void. The fact that my client has been ridden more than Seattle Slew is irrelevant. Standard community property applies, and she is entitled to half of the marital assets, or $11.395 million. Jordan fades back, swoosh, and that's the game. Nothing further, Your Honor.
So you get the idea. You have to remedy the fraud that your client has perpetrated, and don't lie in the court. You probably shouldn't act like that in court either, though. Now we move on to the LEOs. So 278, it's not improper for you to continue to represent a client as a plaintiff and to make use of a document in connection with that representation. The acquisition of the document by the client's wife may or may not have been authorized by the defendant corporation. You can keep representing that client who probably stole evidence as long as you weren't a conspirator, an accessory, or advise them to do it. In other words, you can't advise your client to go out and steal documents. If they bring you stolen documents, you might be able to use them. If they bring you evidence that they have obtained by surreptitious means, you can still ethically continue to represent them as long as you're not a conspirator or an accessory. However, keep in mind, Elio 1702 would require you to hand it back over. So if you're hoping your client didn't get prosecuted for stealing 18 hard drives worth of information, you're going to have to turn it back over. Elio 1445 also relates to that rule. I believe we covered it above. For Elio 743, you can't lie in interrogatories. This seems to be pedantic and straightforward. You can't lie in court documents. In civil discovery anyways, I know criminal is a bit different, but in civil discovery, you have to sign your interrogatories, send them over to the other side. Their treaties are signed under oath. They can't have false statements in them that you know are false. In fact, if you know them to be false, you will have to supplement to correct the falseness. So don't lie in discovery. Elio 1397 had to do with the fact pattern where an attorney had not once but repeatedly signed, we have to certify that we've given the other party court documents, and they had apparently and repeatedly signed that they had given them over when they had not. And this fact pattern said, well, obviously repeated misstatements on required certifications break the rules. Fairly straightforward. They actually said only one time would break the rules. So again, don't lie on court papers. Fairly straightforward. So Elio 194 looks like it's going one way and then changes the course and goes another. If you are defending a case and the other party has filed in a court of improper jurisdiction, you are required to let the court know that it doesn't have jurisdiction. In other words, you can't consent to jurisdiction that doesn't exist. I've come across this once when I was a federal intern. I worked for the Court of Federal Claims. There's some overlap with the Federal Tort Claims Act versus the Court of Federal Claims, in which court you file in, and the defensive attorneys all the time would come in and say, hey, this court doesn't have jurisdiction. So that is somewhat of a decent illustration of what this LEO actually applies to. Also, if you end up with a domestic battery charge in district court and you're the defense lawyer, you have to make this jurisdictional objection before anything goes on. It doesn't always happen, but every once in a while you get a case that slips through the cracks. So that is what LEO requires you to do. So LEO 1103, the fact pattern in this is a debt collector wanted to send out a signed warrant in debt where they put in a bogus return date. So they wanted to send it out to the party to sort of trick them into talking to them where they hadn't filed the action with the court. Obviously, the ethics committee said you can't do that because you're improperly implying that you filed this with the court, that the court has assigned a return date. So in other words, don't send a bogus pleading to another party. Just as an aside, if you had done, this is a bad idea for several reasons, the second of which, aside from the obvious, is not ethical, being if that person then shows up in court on the return date and tells the court about this, you've probably gotten yourself a bar complaint from the court. So don't send out bogus pleadings. Okay. Elio 924 Elio 924 is a somewhat complicated fact pattern, but boiled down, let's say you're representing a client in a personal injury action, and a witness for that client has given 3 successive statements. One statement said one thing, the second statement and then the other, and then the third statement said a different statement. You later find out from the witness the second statement, which is the one that makes or breaks your case, the one that you want to use, was false. The first statement, given at the scene of the accident, which of course doesn't really help your client at all, because that's how these things work out, is correct. And so the question is it proper, if you're negotiating on behalf of your client, to rely on the second statement? You're not at trial. You may not have even turned it over in discovery. So can you negotiate based on a witness statement that you know is false? The Elio comes down with, no, you can't. So if you know that you have false evidence, you can't use it in negotiations. Questions, comments? Bueller? No?